Moses led the children out of Pharaoh's hand, across the Red Sea like God had planned. Well, you think that when he opened up that mighty sea, that all the people would surely believe. But you can hear the sick, raise the dead, turn the sky from a blue to red. It don't matter what they hear or what they see. Some people, they never believe. Noah was the only man on earth that was good, so God said, build an ark of resinous wood. Well, a lot of people laughed and called him a fool, but Noah didn't mind, 'cause he knew for sure that you can heal the sick, raise the dead, turn the sky from a blue to red. It don't matter what they hear or what they see. Some people, they never believe. Shadrach, Meshach, Abednego were told that in the fireplace they must go. Well, you think that when the people saw they just wouldn't burn, that all the doubters would finally learn. But you can heal the sick, you can raise the dead, turn the sky from a blue to red. It don't matter what they hear or what they see. Some people, they never believe. Jesus came to earth to save all men, take upon himself a world of sin. But the people didn't care what he said or he did. They only knew that they wanted him dead. Although he healed the sick, yes, he raised the dead, so he could turn the sky from a blue to red. It didn't matter what they'd heard or what they'd seen. Some people refuse to believe. A lot of people now are dying in sin, waiting for a miracle to prove to them. But though miracles keep happening again and again, they still don't believe, and they never will. 'Cause you can heal the sick, raise the dead, turn the sky from a blue to red. It don't matter what they hear or what they see. Some people, they never believe.
Were you when my night fell and pieces shattered everywhere? If I had loved you with my whole heart, time will tell. Time will tell. Were the stars.
That's Timothy Holmseth. That's quite a while ago when he was younger. I think it was an arrest picture where he had been drinking or something. I can't remember exactly. But Craig Sawyer, real Craig Sawyer, said, "Pray for my most fixated hater and stalker, Timothy Charles Holmseth, a custodian fired for refusing to bathe, has grifted for at least a decade, masquerading as an award-winning journalist, although never employed as a journalist and the recipient of no award." Well, I need to make a small correction there. This is mostly right, but Timothy did work as a reporter for a short time, and he did win an award. But it was a group award. There was a whole group of reporters that did this together, so he was only one person on that award. I actually did some research on that years ago. I had an email conversation with that employer, but other ones, I could find nobody else except that one. And then, like I said, I think he worked as a janitor, but now he just grifts and begs and gets money from people. And then they draw you in with that, and then you believe all the lies. So Holmseth survives on clicks he gets from the unwitting who don't vet their sources. He's claimed to be high command, which literally exists only in the G.I. Joe cartoon and the Pentagon Pedophile Task Force, which has never existed, and that's the truth. Holmseth is obviously unwell, surviving and hiding as a fugitive from multiple warrants for his arrest in Onaka, Minnesota. I guess maybe that's where he's at now. But Holmseth has put others up to publicly carrying his accusations, like Phil McConnell and Daniel John Lee and Fiona Barnett and Randi Erickson, of course, and all of their crew, Jesse. I actually did a narrated version of that lawsuit that he's talking about right here, and I put in, they listed certain videos of his, and I went to each one of those and put those in the video, and I'll put a link to that under here. But Holmseth has been widely exposed, yet continues to grift with outlandish clickbait stories and disinfo as he remains at large. Yeah, it's quite a fiasco.
Moving across the ocean, did the world turn away for just a glance and leave me here in these ashes? I will weep, I will dance, 'cause all I have is yours. All these ashes and these
To read Randi Lynn Erickson, Judgment. And there's the case number at the top, United States District Court, District of Minnesota. Randi Lynn Erickson, and there's the file number, plaintiff and counter defendant. Craig Randall Sawyer, defendant and counter claimant. Opinion and order. Randi Lynn Erickson, pro se. Brendan R. Tupa and I can't pronounce that name. Mesra Kramer, Minneapolis, Minnesota. The defendant and counter claimant, Craig Randall Sawyer. Plaintiff, Randi L. Erickson, filed this lawsuit originally against 3 defendants who she alleged had threatened her in relation for her efforts to combat human trafficking. Erickson's complaint was dismissed without prejudice for lack of subject matter jurisdiction in March 2023. Erickson versus Snyder, that's the number there. Before Erickson's complaint was dismissed, however, one of the defendants, Craig Randall Sawyer, filed a defamation counterclaim against Erickson seeking compensatory and punitive damages and injunctive relief. Erickson failed to answer or otherwise respond to Sawyer's counterclaim, so the clerk entered default. Sawyer now seeks entry of a default judgment that would, if issued, grant injunctive relief requiring the removal of online postings about Sawyer and forbidding future defamatory publications against Sawyer by Erickson, enjoin Erickson from future filings on this matter and any others without a licensed attorney or court approval, award Sawyer his attorney's fees, and enter a monetary judgment of $1,100,000 in compensatory damages and $1,265,000 in punitive damages, for a total damage award $2,365,000 in favor of Sawyer against Erickson. A default judgment will be entered for Sawyer though for lesser amounts than he requests and without injunctive relief or attorney's fees. Sawyer will be awarded $250,000 in compensatory damages and $250,000 in punitive damages. On the record presented by Sawyer, these are reasonable awards. Much of the injunctive relief Sawyer requests would be legally inappropriate. To the extent he seeks legally appropriate injunctive relief, it is difficult to see what practical benefits Sawyer might gain from the requested relief in view of the counterclaims allegations. The authority under which Sawyer seeks attorney's fees does not warrant the imposition of sanctions against Erickson. The basic process for determining whether a default judgment should be entered is straightforward. The entry of default means that the factual allegations of the complaint, except those relating to the amount of damages, will be taken as true. Wright A. Miller and M. Kane, Federal Practice and Procedure, April 2022. Next, it must be determined whether the taken as true factual allegations of the operative pleading, here the counterclaim, constitute a legitimate cause of action, since a party in default does not admit mere conclusions of law. And that just gives the backup on that. If the taken and true allegations of the complaint constitute a legitimate cause of action, then the amount of the default judgment must be ascertained. And then that gives the backup stuff. Start with the factual allegation of Sawyer's counterclaim that will be taken as true. Sawyer is an Arizona citizen. Contrail. He is a veteran of the United States Marine Corps and a former Navy SEAL, having served on the elite SEALs Team 6. Since leaving military service, Mr. Sawyer has maintained a prominent niche in public life relating to his military expertise, including involvement with multiple television broadcasts and documentaries. Mr. Sawyer's success in many of his ventures depends on maintaining a favorable public profile and reputation. In 2017, Mr. Sawyer founded Veterans for Child Rescue, Inc., V4CR, an organization devoted to rescuing victims of child sexual abuse. Sawyer subscribes to a Christian worldview, which includes the views that Satanism and satanic pedophilia are gravely evil, and that child sexual abuse is a heinous crime against Almighty God, against humanity, and against the young victims. He has lived his life, raised his family, established his career, and built his reputation, both publicly and privately, on these values. Mr. Sawyer currently leads a ministry specifically devoted to exposing the evils of satanic pedophilia and or aiding the victims of such crimes. Mr. Sawyer has never met Ms. Erickson, never spoken with her, and has no relationship with her. Erickson is a Minnesota citizen. She proclaims to be a sovereign citizen and a member of a task force that gathers actionable intelligence of international crimes with the United States Army Intelligence Support Activity under the name Pentagon Pedophile Task Force. At the counterclaim's core are a series of allegations concerning statements Erickson has published or republished regarding Sawyer. These are described generally in the counterclaim as follows. Beginning around November 2018, Ms. Erickson, along with cohort Timothy Charles Holmseth, began publishing a multitude of false and defamatory statements against Mr. Sawyer. Ms. Erickson relies on Jessie Marie Schibroder as her source for many of her false and defamatory allegations. Ms. Schibroder claims that she witnessed a murder by Mr. Sawyer, as well as several murders by Hillary Rodham Clinton in Chicago in the early 1980s, which included the raping, torturing, and eating of children during satanic rituals, while Mr. Sawyer watched. Ms. Schibroder named several politicians, celebrities, and other high-profile individuals, such as Ronald Reagan, Bill Clinton, Joe Biden, Newt Gingrich, Dick Cheney, Dan Quayle, Mike Pence, John Kerry, Muammar Gaddafi, Amy Coney Barrett, and Elon Musk, to name a few, as being involved in some satanic cult that tortures, rapes, murders, and eats children. Because of the spectacular nature of Ms. Schibroder's claims, her credibility is broadly questioned across the internet and elsewhere. And Facebook. Cantrell. Mr. Sawyer alleges that several of Ms. Erickson's postings are defamatory. For example, on April 28, 2021, Mr. Sawyer announced that he would be a speaker at a faith conference in Dallas in May 2021. Afterward, Ms. Erickson contacted event organizers and guests, telling them that Craig Sawyer is a human trafficker who raped a child. On May 25, 2021, Ms. Erickson published on the internet at https://bitchute.com that Craig Sawyer is an accused Clinton human trafficker who allegedly raped a child, led a life of crime, committed more interstate wire fraud, pedophile, child sex offender, and attempting to kidnap and kill Timothy Charles Holmseth. Ms. Erickson and Mr. Holmseth had a special section on their website dedicated to Mr. Sawyer, located at timothycharleshomseth.com, Craig Sawyer, which has over 100 postings mentioning Mr. Sawyer with false statements, including, but not limited to, stating that Mr. Sawyer is a child rapist, serial killer, contract killer, pedophile, drug trafficker, potential presidential assassin, and that he formed a heavily armed domestic terror group and kidnapping operation that is ripping people off and working with human traffickers as a way to make himself appear to be anti-trafficking. And I'll tell you right now, just my insertion, anybody who ever gets close to Timothy Charles Holmseth ends up like this. Or if it's somebody that's doing something good and he's very jealous of it. And because Craig Sawyer has an organization dedicated to rescuing children, and because Timothy Holmseth claims to have an organization rescuing children, which is not only a lie, it's completely false. There is no Pentagon Pedophile Task Force. That's all made up in their heads. Just like the Children's Crusade with Phil McConnell was just all made up. There was one many years ago which had been shut down many years before this. It was never registered as anything, had nothing to do connected with the government or anything else. This is how sick these people are. Okay, end of my rant. On October 15, 2021, Erickson posted a video of a recorded phone conversation between Miss Erickson and Robert, oh, my eyes are getting blurry here, Cottle, a preparedness program administrator for the Texas office of the governor. Beginning at 1:38, Ms. Erickson states that Craig Sawyer is involved with child trafficking, and she has proof of that. Internationally, such as allegations is completely false. Beginning at 10:14, Ms. Erickson states that Mr. Sawyer is operating an independent battleground on child trafficking, but he has not rescued one child. This is false, as the V4CR has made 23 arrests with a 100% conviction rate as a result of its joint sting operations with law enforcement. The truth is that Timothy Holmseth and Jesse Shibroder have never rescued one child anywhere. All they've done is take in money and get clicks. On November 5, 2021, Miss Erickson published an apparent account from Adrian John Wells, who, in my opinion, is another fraudster, grifter, that was real cozy with Phil McConnell, that states that he was kidnapped from his family home in Australia in 1984. Then Mr. Wells was transported by Mr. Sawyer to a U.S. Army and Hollywood police pedophile ring involving Harvey Weinstein, then to Arkansas for a pornography deal with Bill Clinton and Hillary Clinton. Then to New York City, where he was raped by a U.S. Army soldier in the bed of a New York City apartment, possibly owned by then Senator Joe Biden. Mr. Wells then states that he was tortured by the CIA under arrangements made by Michael Flynn. This video also posts excerpts from an affidavit of Jesse Shibroder, insert again, which is full of lies, a vivid imagination, extraordinary claims, and sensationalized rhetoric to bring in more clicks and more money. These are, in my opinion, sadistic, narcissistic sociopaths, which describes incidents in a suburb of Chicago, Illinois, between 81 and 84 involving Hillary Rodham Clinton, along with Mr. Sawyer serving as her protector. Ms. Shibroder's affidavit states that she witnessed torture and murder of a man who tried to escape the Luciferian system. And I'm going to insert again. The truth is, from what I've seen, and in my educated opinion, that Jesse Shibroder is a practicing Satanist. She teaches people how to do it under the guise of just informing them. She knows stuff that she shouldn't know unless she was in it. Of course, she claims to have been in it, and she claims to have, been part of the Mothers of Darkness. And it is very questionable whether that even exists, because even her grandmother, from what I've heard, has come forward, and she is just terribly hurt and disgusted by what Jesse Shibroder's doing. Now, that was told to me. I don't have solid evidence for that, but that was told to me by others who know a lot more about Jesse Shibroder than I ever did. But I've watched many of her shows with other New Agers where, she encourages her followers to go into witchcraft stores and look at all the potions and stuff like that. Like she's training them to be witches or something. Maybe that's just my imagination, but I don't think it is. Ms. Shibroder's affidavit states that she witnessed torture and murder of a man who tried to escape the Luciferian system. Further, Ms. Shibroder's affidavit states that she witnessed Mrs. Clinton murder 4 girls around the age of 10, but not before torturing them, sexually abusing them, and allegedly eating parts of their bodies, all while Mr. Sawyer was present, watching, and yelling at the children to quit crying, you little babies. This video has been viewed over 16,000 times. It's just sickening. There's a lot of bad stuff going on out there. But these people, they got to make it a million times worse. It's just crazy. Miss Erickson's internet video publications, as described above, were published with deliberate intent and with Miss Erickson knowing the accusations to be false or in reckless disregard of the truth. Further, Miss Erickson published them with knowledge that Mr. Sawyer would suffer the injuries described in his counterclaim. Miss Erickson, in conjunction with Mr. Holmseth, has caused irreparable injury to Mr. Sawyer's reputation, profession, trade, and businesses through her continual false and deliberate publications accusing Mr. Sawyer of engaging in, among other things, I couldn't figure out where that was going, but that's just showing the bottom of the page, because I tried to put everything in there. But it's an addendum. Sawyer attached as an exhibit to his counterclaim an exemplary list of 79 videos published by Miss Erickson and Mr. Holmseth with their dates, titles, and links to their locations on the internet, and alleges that the videos have been viewed several thousand times. So, Mr. Sawyer of engaging in, among other things, the most heinous crimes of pedophilia, child sex trafficking, and murder. Erickson's publications have caused Sawyer to suffer public hatred, contempt, ridicule, and aversion, have created hostile and unsavory opinions about Mr. Sawyer in the minds of a substantial number of people, have dissuaded people from associating with, supporting, and contributing to Sawyer and his business and organizations. And that's what they do. That's what they do. These people are evil. They're not just sociopaths, they're evil, vindictive, hateful, putrid, sickening. And I hate to even say it, human beings. Just twisted. And have caused, and okay. And have caused and encouraged others to republish her defamatory statements on their own social media accounts, thereby further increasing the audiences who hear and view the statements. Mr. Sawyer will continue to suffer such injury into the future unless Miss Erickson is restrained from publishing and republishing her false, groundless accusations that Mr. Sawyer is engaged in the most heinous of crimes. And it brings in the money and the clicks. That's the main reason they do it, other than being pure evil. These people are evil. They have no connection whatsoever to President Trump. And yet there's people all over the place republishing these stuff. Ariel, who has over, I can't remember exactly, seemed like around 500,000 followers, has used Timothy Holmseth and Jesse Shibroder as sources for a lot of the propaganda that he puts out. And yet he has millions and millions of views. I mean, even Michelle Moore pushing Jesse Shibroder. She claims not to know who Timothy Holmseth was, yet she was pushing him too. And Michelle Moore has got so many people fooled. So many people. She's not a sweet Christian lady. And that is my opinion from looking at what she produces. And I'll tell you how Timothy got to have such a large following. Because he didn't have that many followers in the beginning. I was there. I listened to him for about 20 minutes and knew that he was sick in the head. I don't know how any intellectual or intelligent person could listen to him for 10 minutes and not know this, or just look at him. I don't know what he went through in his younger years. He was adopted, but I tell you, he's got some of the most twisted, sickening psyche I've ever seen in my life. But 107, Agent Wayne, Agent W, who claimed or who allowed people to believe he was JFK Jr. for years, is the one that got Timothy Holmseth pushed out so far into the limelight. Timothy got into Phil McConnell's show, which was, where he was Phil had a lot of viewers. I was there the day he called Wayne Willett JFK Jr. in front of 70,000 people. And then he started having Timothy on there. And then he went on other people's shows and uplifted Timothy and how we needed what Timothy had to offer and all this stuff. And Timothy's numbers just started shooting up through the roof. That's how that got started. Because they thought Field was credible. And they thought 107 was credible. And both are as far from the truth as you can get. So, sorry, I just had to put that in there. Supporting and continuing, okay. The case's procedural history is somewhat unusual. Erickson filed her complaint in November 2021. Sawyer moved to dismiss the complaint for improper venue and failure to state a claim on which relief may be granted. One of Sawyer's co-defendants, Robert Hammer, I don't know who that is, subsequently joined in Sawyer's motion, ECF number 14, In March 2022, Erickson's complaint was dismissed for lack of subject matter jurisdiction because she alleged no state claims to invoke diversity jurisdiction, and she failed to identify a substantial federal question. And Sawyer and Hammer's motions seeking dismissal on venue and merits grounds were denied as moot. Between January and March 2022, Erickson filed a series of groundless motions. She also filed several affidavits and many pages of exhibits. Boy, they're proficient in making affidavits, I'll tell you that. But that affidavits don't mean anything in the grand scheme of things, because affidavits is just somebody's opinion. Erickson's motions were denied in 3 orders. Though the purpose of Erickson's affidavits and exhibits were not clear, they were allowed simply to occupy the docket. On February 15, 2022, after she filed his Rule 12 motion, but before the complaint was ordered dismissed, Sawyer filed an answer and counterclaim. Erickson filed no response to Sawyer's counterclaim. She lodged no objections to its filing on any ground, including timeliness. On March 9, 2020, Sawyer moved under Rule 12 to strike Erickson's various affidavits and exhibits, and moved under Rule 55 for default judgment. Because these motions were procedurally improper, they were denied. The following week, Sawyer applied for the clerk's entry of default, and the clerk entered Erickson's default on April 15. Sawyer originally scheduled a hearing on his default judgment motion for August 1, 2022, after missing the deadline to file papers in connection with that hearing case. The hearing was rescheduled and took place on November 28, 2022. One might reasonably question the procedural propriety of filing an answer after filing a Rule 12 motion, and before the motion is decided. Regardless, Rules 12 and 13 do not seem to prohibit a defendant from filing a Rule 12 motion and a counterclaim. Although Erickson's complaint was dismissed for lack of subject matter jurisdiction, that does not prevent the exercise of subject matter jurisdiction over Sawyer's counterclaim, provided it alleges an independent basis for the subject matter jurisdiction. Sawyer's counterclaim plausibly alleges the presence of diversity jurisdiction under blah, blah, blah. Number 72. At the hearing, Sawyer declined the opportunity for an evidentiary hearing, explaining that any testimony he might offer in such a hearing would be identical to his affidavit testimony, and the record would not otherwise change. Under the common law, a plaintiff pursuing a defamation claim must prove that the defendant made A, a false and defamatory statement about the plaintiff, B, in an unprivileged publication to a third party, C, that harmed the plaintiff's reputation in the community. A statement is defamatory when it tends to injure the plaintiff's reputation and expose the plaintiff's public hatred, contempt, ridicule, or degradation. And that just gives all the reasonings there. The common law recognizes privilege, both absolute and qualified, that operate to defeat a defamation claim. Absolute privilege means that immunity is given Sawyer argues that Minnesota law governs his claim in this case in light of Erickson's Minnesota citizenship. There is no good reason to second-guess Sawyer's position. It doesn't end up making a difference, but to be clear, I understand the Minnesota Supreme Court formulation of the claims elements in, I can't see that word right there, to mean that it is a plaintiff's burden to show that the defamatory statement's publication was unprivileged. On other occasions, the court has described privilege as a defense to a defamation claim. Okay, this goes back a little ways, because what I was just reading was the addendum at the bottom. Absolute privilege means that immunity is given even for intentionally false statements coupled with malice. Mathis versus Kennedy. A qualified privilege is overcome if the plaintiff demonstrates that the defendant made the statement with malice. Malice under the common law means that the defendant made the statement from ill will and improper motives, or causelessly and wantonly for the purpose of injuring the plaintiff. Defamation plaintiff generally must establish harm to reputation. But harm to reputation is presumed in cases of defamation per se. That is, cases involving false accusations of committing a crime and false statements about a person's business, trade, or professional conduct. The analysis changes somewhat if the plaintiff is a public official or public figure. The First Amendment prohibits public officials or public figures from recovering damages for defamatory falsehoods concerning issues of public interest and concern unless they prove that the statement was made with actual malice, that is, with knowledge that it was false, or with reckless disregard of whether it was false or not. And this is given the other cases there. Defining actual malice and noting that it is important to distinguish between actual malice and common law malice. That's interesting. The public figure category is broader than persons who, by reason of pervasive fame and notoriety, become public figures for all purposes. More commonly, an individual voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Whether a defamation plaintiff is a public figure depends on context, specifically by looking to the nature and extent of an individual's participation in the particular controversy giving rise to the defamation. Identifying the factors as determinative of the limited purpose public figure question, whether a public controversy existed, whether the plaintiff played a meaningful role in the controversy, and whether the alleged defamatory statement related to the controversy. The analysis is similar if a private plaintiff, that is, a plaintiff who is not a public official or public figure, sues a defendant for defamatory statements involving a matter of public concern. In this situation, the plaintiff must also establish actual malice. There is not a bright line between statements that involve a matter of public concern and statements that do not, as the Minnesota Supreme Court explained in Mothner. Notwithstanding the importance of the distinction between a public concern and a private concern in determining the constitutional protection afforded to speech in tort actions, the Supreme Court has acknowledged that the boundaries of the public concern test are not well defined. But the court has articulated some guiding principles. In Snyder, the court explained that speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when the subject of the speech is of general interest and of value and concern to the public. The court can make clear that the subject of the speech is not the only consideration. According to the court, deciding whether speech is of public or private concern requires an examination of the content, form, and context of that speech, as revealed by the whole record. Relevant considerations include, for example, the subject or subjects of the speech, the location of the speech, and whether it was designed to reach a broad audience. The taken as true factual allegation of Sawyer's counterclaim plainly meet the common law defamation's claims basic elements. The many statements Sawyer alleges Erickson made to the effect that Sawyer is a human trafficker, a pedophile, child rapist, a serial killer, and so forth are defamatory. They obviously would tend to injure Sawyer's reputation and expose him to public contempt. The statements are also false. It is enough in this procedural context that Sawyer alleges the statements are untrue. The counterclaims allegations give no reason to think that any of Erickson's many statements were privileged. There is, for example, no allegation that any of her statements were made in a judicial proceeding as part of a report to law enforcement or in any other conceivably privileged context. Though many of Erickson's statements are defamatory per se, at least because she accuses Sawyer of multiple crimes, including false imprisonment, child sexual assault, and murder. Sawyer's allegations that Erickson's statements have caused significant, irreparable injury to his reputation and business interest is established by virtue of Erickson's default. The determination that the counterclaims taken as true allegations constitute a legitimate cause of action for defamation holds if one concludes that Sawyer was required to show actual malice. The counterclaims allegation that Sawyer has maintained a prominent niche in public life and that he founded and leads an organization devoted to rescuing victims of childhood sexual abuse. After all, might fairly be understood to make Sawyer at least a limited purpose public figure with respect to the subject of child serial abuse, the principal subject of Erickson's defamatory statements. And the counterclaims allegations regarding the content, form, and context of Erickson's statements might reasonably be construed to show that the statements involve a matter of public concern. If the content of Westboro Baptist Church member speech addressed broad issues of interest to society at large, then so did much of Erickson's. Though many of her statements were directed at Sawyer, many others were directed at groups of national government and political figures and subjects like democratic terrorism or domestic terrorism. Most of Erickson's statements were made online in websites and formats designed to reach, and as Sawyer alleges, did reach an extensive audience. The actual malice determination follows, not merely because Sawyer alleges it, countered, but also because it is difficult to imagine how Erickson's statements, considering their frequency, substance, and outrageousness, could have been made without her knowledge of their falsity or her reckless disregard for whether the statements were false. They don't care about that. I can tell you right now, I've seen too much. They don't care whether they're true or not. It's what they want to believe, and they want to destroy people. Now, I don't know Craig Sawyer, but there's just no way I believe all that stuff. I have, I've spoken to him in posts and stuff like that, and I've always thought he was a really nice guy. Seemed very sincere. I mean, we don't have the same views on everything, but that's to be expected. Be kind of a boring world if we all thought just exactly alike, wouldn't it? But from what I've seen of Craig, and I did do another narrated legal documents for Craig and others. There was, I think, 4 against Daniel John Lee, and Timothy Holmseth was also listed in that, along with Fiona Barnett and I think it was like 10 other people that were doing the same thing years ago. They don't stop. They never stop. It's what they live for and breathe for, is to destroy people. There's a difference in exposing somebody who's doing horrible things, which is basically what we're doing here, than just spouting off a bunch of nonsense. Like Timothy, I'd say he might have 10% stuff that's true. The rest of it's just all made up or stretched to the max. Sensationalized. That's what they like, and that's what people want. They want to hear the ucky gory stuff, whether it's true or not. A lot of people don't even care. God, why would anybody want that stuff to be true? And I know there's, like I said, a lot of evil out there. But I'm not going to say something unless I know it's true. I have experience with these people. I've been watching them since 2017. And some even before that, so. So anyway, I'll try to finish reading this. I don't hate anybody. But, you know, there are certain things that even God hates. And you can love the sinner, but hate what they're doing. And I hate what these people are doing. And I don't say that lightly. Even after a defendant's liability is established, a plaintiff seeking a default judgment must still prove its actual damages to a reasonable degree of certainty. Everyday Learning Corp. Larson. It's another example. A district court may determine damages by computing from the facts of record the amount that the plaintiff is lawfully entitled to recover and enter judgment accordingly. Under Minnesota law, damages available to Sawyer include harm to his reputation and community standing, mental distress, humiliation, embarrassment, physical disability, and any economic loss, to the extent these are caused by Erickson's defamatory statements. The determination that Erickson acted with actual malice also makes punitive damages available to Sawyer. Sawyer requests that he be awarded $1,100,000 in compensatory damages and $1,265,000 in punitive damages. The request draws support from essentially three sources. First, there are damage allegations in Sawyer's counterclaim. These are quite general. Second, Sawyer has filed an affidavit in which he describes how Erickson's statements have injured him. Sawyer testified, for example, that Erickson has done immense intentional damage to me, my family, and our organization for children, Veterans for Child Rescue. I'm sorry, I'm hesitating because I can barely see this on my phone. My eyes aren't as good as they used to be. He testified to a series of emotional harms. These include feeling stunned and distraught, hurt, bewildered, assaulted, and degraded. Feelings Sawyer testified are amplified because Erickson's statements are so at odds with his faith, his service to the country, and his work through Veterans for Child Rescue. Sawyer testified that Erickson's statements have caused a cutback in support for his activities and greatly damaged his reputation in the Christian community. And he testified that he has lost public support, moral support, law enforcement, and film and television friendships and alliances. Third, Sawyer has filed a default judgment entered in his and three others' favor in the Stark County, Ohio Court of Common Pleas. In that case, Captain Hagman versus Lee, case number there, the court entered default judgments for Sawyer on a defamation claim. And there's the number there. The court entered default judgment for Sawyer on a defamation claim involving statements comparable to Erickson's made by a defendant, Daniel John Lee, on 4-5, describing statements made regarding Sawyer. Following an evidentiary hearing, the court awarded Sawyer $1 million in contemporary damages, and it awarded Sawyer and his three co-plaintiffs $1,150,000 in punitive damages, apparently jointly. Now that's the other legal document that I did where Craig was in it and Dan Hagman, and there was four of them altogether. I can't recall all the names. Steve Quayle. I think Steve Quayle passed away. I'm not sure about that, but I thought I heard that he had passed away. That court based its compensatory damages award largely on testimony and exhibits showing extraordinary harm to Sawyer's reputation and a loss of confidence in Sawyer's nonprofit work. The court based its punitive damages award essentially on the magnitude of defendant Lee's actual malice. That was a horrible. I'll put that link under here because I uploaded it on here, and it was horrible. I showed videos and everything of him doing it. The sources plainly established that Sawyer has suffered and likely continues to suffer significant reputational injury and mental anguish caused by Erickson's defamatory statements. But these sources do not support a judgment in the amount Sawyer seeks. The counterclaims allegations are too general to be of use in ascertaining a damages award. Sawyer's affidavit is more specific. It includes credible descriptions of substantial reputational injuries, mental distress and anguish, and embarrassment. It does not include other information indicative of more severe injuries. It omits, for example, testimony showing that Sawyer's mental distress injuries were severe enough to prompt him to seek mental health care or other medical treatment, and it includes no testimony showing that Sawyer personally suffered continuous or economic loss. The default judgment caused in the Ohio court is informative, but its usefulness is undercut by the fact that it was issued following an evidentiary hearing concerning statements made by a different defendant. But my insertion here, Timothy Holmseth was also included in that lawsuit, along with Fiona Barnett, and I think Randi Erickson was in there too. So I think they were all in that lawsuit too, and they'd learned nothing by it. I don't know if Craig ever even got any money out of them. I mean, they're criminals. Further, though Sawyer asserts that he should receive the punitive damages amount awarded in the Ohio case increased by 10% for inflation, the order is that case makes clear that the $1,150,000 in punitive damages was awarded collectively to the 4 plaintiffs in that case. Assuming each plaintiff shared equally in that award, Sawyer's portion would be $287,500. On this record, I conclude that Sawyer is entitled to a compensatory damages judgment of $250,000. Several primary considerations led me to award this amount. The contents of Erickson's statements is extreme. The content is extreme. It is difficult to imagine content more defamatory than accusing another of being a pedophile, child rapist, kidnapper, fraudster, and serial killer. Erickson made many statements. Sawyer has introduced evidence of dozens of such statements. Erickson deliberately made these statements in a manner intended to reach an audience that is at least nationwide. She utilized the internet to publish her statements, notwithstanding their outrageous content. The record shows that Erickson found a wide audience for her statements. Sawyer has testified that he has suffered and continues to suffer significant reputational injury and mental anguish caused by Erickson's defamatory statements. In view of the statement's content, frequency, and scope of publication, and in view of the obvious contradictions and problems each statement would pose given Sawyer's faith and service in present-day charitable work, I find that Sawyer's injury-specific affidavit testimony is credible. No doubt Sawyer has had to endure embarrassment, my eyes are starting to cross, and devote considerable time to answering the statements and countering their deleterious effects on him personally. It is true that Sawyer's damages testimony is not very particular, but in view of the nature of damages awards in defamation cases generally, his testimony and the larger record are sufficiently specific to permit the assertion of damages with a reasonable degree of certainty. Viewed alone, these considerations arguably justify a higher award than $250,000. I decline to make a higher award based largely on the absence of evidence showing that Sawyer's mental distress has been more severe. There is, for example, no evidence showing that Sawyer has required mental health or medical care. And in the absence of evidence showing that Sawyer has sustained identifiable economic loss resulting from Erickson's statements, I also conclude that Sawyer is entitled to a punitive damages judgment of $250,000. The legal basis for this award follows from the earlier conclusion that Erickson acted with actual malice. The actual malice standard that a person publishes a defamatory statement with knowledge that it was false, or with reckless disregard of whether it was false or not, mirrors the these words are getting smaller by the minute. Mirrors the standard for awarding punitive damages under Minnesota law. And then it states the laws there. Several coincidences lead me to conclude that $250,000 is the right amount versus Minnesota law. Erickson's defamatory statements were outrageous, frequent, and intended to reach the widest possible audience. Erickson encouraged and caused others to republish her defamatory statements, multiplying the injuries her own statements caused. Sawyer has received death threats owing to similar statements made by others. It is then reasonable to infer that the hazards arising from Erickson's statements are quite serious and extraordinary. Erickson published the statements over an extended period, at least several months, been years. Erickson's conduct and filings in this case suggest that she remains defiant and intent on injuring Sawyer. She has filed multiple declarations and many pages of exhibits in this case in which she seems bent on defending her position and statements. It is bewildering that she went to the trouble of filing these voluminous materials, but chose not to respond to Sawyer's counterclaim. That is interesting. Regardless, there is a demonstrated need for deterrence. The amount is close to the punitive damages awarded by the Ohio court, and it bears a reasonable 1.1 relationship to the compensatory damages awarded here. The law and practical considerations weigh against entering a judgment that would include any of Sawyer's requested injunctive relief. To recap, Sawyer seeks an injunction that would require Erickson to remove online postings about Sawyer and forbid Erickson both from publishing future defamatory statements regarding Sawyer and filing anything further in this case without representation or court approval. Let's see. In order for a district court to grant a permanent injunction, the plaintiff must show that he will suffer irreparable harm if the injunction is not granted. Sawyer has not explained why a damage award, particularly the punitive damages component, is not an adequate remedy or deterrent against Erickson publishing future defamatory statements. Sawyer's request for an injunction targeting future defamatory statements would be a prior restraint, but Sawyer has not explained why this case poses such extraordinary circumstances to make a prior restraint justified or workable. So the last there is just describing, recognizing that something seeking a prior restraint bears a heavy burden, and that courts should tread cautiously when considering injunctive relief against future publication. Well, she'll just keep doing it. If you don't put her in jail or do something, she'll keep doing it. She's a narcissistic sociopath, in my opinion, because it matches everything that I've read in mental health peer-reviewed reports. But she'll keep doing it. Courts take a dim view of the prior restraint of expression and exceptions to the general rule against such prior restraints are recognized only in extraordinary circumstances. Well, if you knew these people, you know she's going to do it again. Though these legal issues aside, practical considerations cast substantial doubt on the requested injunction's possible effectiveness. That's true, too. Even if you ordered her not to, she's going to do it. She's like Phil McConnell. These people are sick in the head. The counterclaim includes numerous allegations regarding the extensive republication of Erickson's statements and others' extensive publications of their own, similar defamatory statements. In other words, as Sawyer describes things, there is an ever-expanding volume of defamatory information on the internet, much of this republished by others from Erickson's original statements, and much originating from others. Without intending to undertake the situation's gravity with respect to Sawyer, it is difficult to envision how the injunctive relief requested as to Erickson might make any particular difference. And honestly, it probably won't. I mean, Phil McConnell had to end up in jail, in house arrest. It seemed like it was a couple of years. And he's ordered, not to ever do that again. Well, Timothy's already been ordered not to do it by the attorney that he harassed for years. And so he sold all of his rights to his publications to Randi Erickson so she could do it. So he's been keeping his mouth kind of shut. But Randy's been going out there. She's been using Wayan's recording and everything else. Wayan Kruger, the one that Timothy also harassed for years until she died. He was still harassing her when she died a couple of years ago. So he's making a good point here. How would it make any practical difference? She's crazy enough to do it to start with. She'll do it again. Finally, though Erickson's litigation conduct has been confounding, the record does not show the presence of factors warranting imposition of a filing restriction. So they're trying to walk a fine line here between freedom of speech and criminal speech. Sawyer's request for attorney's fees also will be denied. Section 1927 says any attorney or other persons admitted to conduct cases in any court of the United States who so multiplies the proceedings in any case unreasonably and vexationally may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. The circuits are split as to whether 1927 applies to non-lawyer pro se litigants. The Eighth Circuit has not weighed in on the issue. Assuming Erickson could be sanctioned under 1927, the better answer is not to do that. It is true that Erickson filed several frivolous motions, but those were denied without Sawyer having to respond to them in any meaningful way. It also is true that Erickson has filed many pointless affidavits and exhibits, but Sawyer didn't have to respond to those either. If anything, Erickson's default on Sawyer's counterclaim and her failure to reopen to the default judgment motion enabled a more streamlined, less costly resolution of the merits of Sawyer's defamation claim. So is he saying that she didn't even respond to this? I think that's what he's saying. In view of the case's procedural history, it is difficult to understand, and Sawyer has not explained how Erickson's conduct caused him to incur excess costs, expenses, and attorney's fees. Well, the fact that he had to pay any attorney's fees, she should have to pay for it, in my opinion. It also seems worth mentioning that Sawyer, too, has filed motions and other papers that did not comply with the rules, and that made resolution of the case somewhat more time-consuming. All things then considered, then I conclude that the imposition of 1927 sanctions against Erickson is not warranted. Sawyer did not seek sanctions in response to Erickson's filing of this case. Order based on the foregoing and on all files, records, and proceedings herein, it is ordered that counterclaimant Craig Sawyer's motion for a default judgment is granted in part. Judgment is awarded to counterclaimant Craig Sawyer and against counter-defendant Randi Lynn Erickson in the total amount of $500,000 to bear interest in the statutory rate from the date of judgment. The motion is denied in all other respects. But judgment be entered accordingly, January 12, 2021. Oh, no, 2023. So this was a year and a half ago. Eric C. Tufts, I can't see that. United States District Court. And that was page 22. There's Timothy Charles Holmseth when he was a young man. Like I said, I don't know what he's been through in his life before this happened, or if something caused this to happen to him, or if he was born this way. But he's one sick, twisted person. I've actually prayed for him because I don't want to see anybody go down. And anyway, that's the end of that. God bless.